Thank you. You may be seated. Good morning and welcome to the first DCA. We have one case on our docket this morning. Case number 24-153, Florida Department of Revenue versus Bank of America. Appellant's counsel, when you're ready.
Good morning, Your Honors. My name is Robert Shank for the Florida Department of Revenue. I'd like to reserve 3 minutes for rebuttal, if I could.
Ready?
The trial court here granted summary judgment to the bank, believing that the bank had established its entitlement to exemptions for 2 taxes, the stamp tax and the intangible tax for mortgages and loans issued for real estate in the state of Florida. But that order is rife with error. Now, I'm not going to sugarcoat this case. It is complex, but I'd like to boil it down into 2 simple errors for you. First, the bank introduced no admissible evidence to show that it met the exemption criteria for its almost 10,000 loans involved in this case. The court awarded it nearly $5 million of the state's tax revenue based on little more than 3 documents that the bank said were representative of all documents in the case.
Well, I mean, and let's address that area, because there were several years of document exchange, and I think the attorney below stipulated that everything had been given by Bank of America, and then on the spreadsheet of defenses that the department provided, that was not a defense. There was no argument that there hasn't been sufficient documentation to prove that exemption or attachment of those mortgages and note. So can you give us a little more information or your position on that?
Certainly, Your Honor. So I want to break down your question into a couple of pieces. So when it comes to the spreadsheet and what the parties discussed in the audit before litigation, I don't see as particularly legally relevant here. What matters here is that in the context of litigation, what the department said is under Celotex, we don't think that you can produce admissible evidence to prove that you met these exemption criteria. And you can see that especially clear in our reply to summary judgment below, where we laid out here are the exemption criteria and here's why we need these loans in evidence in this case to prove those criteria. And when you do that under Celotex, it's the bank's burden to come forward with admissible evidence, and they didn't do that. The fact that the parties might have exchanged some of the documents outside of the scope of litigation, or may have had a spreadsheet about summarizing some of the loan transactions before the litigation started, doesn't prove the exemption criteria for the nearly 10,000 loans involved in this case before the trial court here. And I'll also just note that the spreadsheet only documents roughly 900 loans, whereas this case involves almost 10,000.
But wasn't that by agreement of, the department and the bank that, we have almost 10,000 transactions at issue here. We're going to agree to do a sampling, and in the department's motion for summary judgment below, page 207 of the record, the department made the statement, the parties have agreed to use this sampling as the evidence in this case. That's page 207 of the record, paragraph 6 of your motion. Haven't you kind of waived any objections to the spreadsheet coming in and being considered?
Well, I don't think so, Your Honor, for a couple of reasons. Again, I think that much of the spreadsheet's use was relevant to the audit, which the department used to try and streamline the exemption process and figure out, okay, how much of a deep dive are we going to have to do into these loans?
But as part of that audit, using the sampling of the 10%, didn't you do the deep dive on the documents and the notes, and weren't they provided? So the department did a deep dive on it all?
Yeah.
So it wasn't...
So I think the audit is just legally irrelevant. Once you come into court, you have to prove what you've done in court. This is an appeal of the audit, right? They filed this lawsuit separately from the audit. And I'll just note, both with this discussion in our motion for summary judgment as well as in the audit, the bank determined that none of the loans met these criteria. And of course, I understand that we said that we were going to use the audit as a baseline, of course, I would point you to our reply where we say and make clear, both at the hearing and in our reply, that we believed in order to establish several of the exemption criteria, including that these were in fact renewals, and that they continued the same obligations, we needed to see those loans and evidence. Otherwise, it would be proving the contents of a writing without having those writings and evidence.
So one of the results of the audit was a spreadsheet that linked the old loans with the new loans. So there we have an old loan that's linked. So when you start talking about renewal or refinancing, well, a link seems to be established in the spreadsheet. So is what you're talking about now something that wasn't given to the clerk's offices?
I suppose it's been a bit since I've looked at the spreadsheet in detail. I don't believe that the loan documents were put into evidence in the spreadsheet or otherwise.
Well, it was a summary document.
Right,
It had
but
the old
again-
loan, and it had the new loan, it had the old obligation, it had the new obligation. So it all seems to be, the link seems to be there in the record. Like, this is the old loan, this is the new loan, the same borrower. Here are their two loans.
I'm not sure whether that link was available to the trial court, to be in candor, Your Honor. But of course, I think it's important to note that even if they were, again, the spreadsheet only detailed 900 of these, and there were other requirements that the bank clearly failed. First of all, we think that the satisfactions precluded these from being renewals under the plain reading of this statute. But also, I think maybe the cleanest way in the stamp tax of noting that these are not exempt loans is the fact that the bank has all but conceded that it never attached or properly notated the old loans.
Didn't it say it tried to, but the clerk's office rejected it?
No, I think what the bank has done here, Your Honor, is to try and confuse the loan documents and the mortgage documents. What they say is that the clerks would reject the mortgage documents. But the statute is clear. The loans, the things that they're not trying to record, are the documents that need to be attached and notated properly. But also, I think that,
Well,
I understand
As a
that.
practical matter, though, when you go into the clerk's office, are the clerks automatically, just about in every case, double taxing, and then you can ask for a reimbursement? I mean, is the clerk having to make a substantive decision with presentation of documents whether there's a qualification as a refinance or a renewal?
So I guess I can't speak to what clerks do in every instance. Based on my conversations internally within our office and with the Revenue Department lawyers who are more often deal with what's going on with the clerks' offices, is that they do review this. And so I think the fact that the clerks were rejecting these mortgages might have been an indication that they believed that they were failing some of these requirements. But again, the clerks, I mean, even if the clerks did require that taxation, if they could just attach and notate the loan documents properly, which again are not the things they're trying to record with the clerk's office, then they would be able, even if the clerks double tax them, as they say, they would be able to get the
The note is only required to
exemption.
say that it's only required to refer to the mortgage, essentially, right? I mean, there's statutory language that says what's on the note. And my understanding is there isn't a dispute about that language was on the note.
I don't think that I suppose, are you talking about the attachment and notation requirements, Your Honor?
Well, here, there's a notation that's put on the mortgage, and I understand that the note essentially refers you to the mortgage and says that that's where you'll find the tax that was paid.
Well, I don't believe that they had the required notation and attachments for the loans. I'm not sure exactly what appeared on the face of the mortgages. All I can tell you is that the statutory requirement for an exemption requires that the loan documents, regardless of what you do with the mortgage, be attached and notated properly. And again, if you turn to the substantive tax provision, not the exemption, but the tax provision in 20108, it expressly says, even though the tax in a situation where you have a mortgage, even though the tax is levied on the mortgage, then there needs to be a notation that tax is paid on the loan. So that confirms that there's always going to be a notation on the loan. And that exemption provision in 20109 tells you the style of notation that needs to appear. And the bank
Was
has
this
never.
argument preserved below? Because of course, I read the transcript twice, actually, and the attorney at that hearing said, we got all the documents we need. Where in the transcript of that hearing did counsel at the lower level preserve the argument you're making now?
So I would point you first, I think the clearest example of preservation, I mean, this question was before the court, is in our reply on page 340 to 341 of the record, where we say that the bank has not showed that on page 341 specifically, it says, do the renewal notes attach the original promissory notes with the language required by 201.1 through 3? The answer is clearly no. I suppose that I could take one more look at the transcript when I sit down, but I believe that there were some references made in the hearing. But again, this question, as we can see from the reply, was at least presented to the trial court. So I do think this argument was preserved.
And does this go to being entitled to summary judgment as a matter of law, or a genuine dispute, factual dispute? What does that go towards?
Well, I think it's both. I mean, my friends on the other side dispute that the attachment or notation requirements even apply as a legal matter in mortgage transactions. I think we do a good job in our brief of laying out that's just not true. It does apply here.
And reading the transcript, it seemed like at multiple times at the hearing below, counsel for the department conceded that there were no factual disputes. So
I disagree. I think that counsel for the department was maybe not in the most artful way explaining that he thought that the satisfaction argument was a legal argument, but I think throughout there were some discussions about the fact that there weren't the loans and evidence and that the affidavit was insufficient. There were factual and evidentiary arguments made, and the trial court understood that
But multiple times, at page 535 of the record, 548, 557, the trial court kept pressing, are there any factual disputes remaining? And counsel repeatedly said, not that I know of, Judge. I think that's what's left are issues of law. No, Judge. So moving to just the legal arguments, staying away from the evidentiary factual arguments, what's your best argument? Walk me through the statutes. What's the difference between 201.08 and 201.09? How do those statutes operate together, and what's the purpose of each statute?
And I'll give you extra time, so feel free to answer fully.
May I just address the legal factual argument distinction just very briefly, Your Honor? I think that once we push them on Celotex to establish evidence, I suppose it could be a pure question of law of if there is no evidence, have they met the requirements here? But I'll just take your question head on about how this statute 20108 and 20109 and the stamp tax operates. So 20108 says every time you have a mortgage that's on real property in Florida, the state imposes a stamp tax. And so you have a mortgage document and a loan document in all these transactions. And the tax is technically levied on the mortgage, but it says you use the loan's value to determine how much tax you're going to pay on the mortgage. And then that, I believe, is paid at the time of recordation. And when you go to 20109, it asks, in what circumstances are those mortgages going to be tax exempt? So that's, it's 20109 is broken out into 3 subsections. The relevant one here would be 20109.2 that says, in order to understand whether a mortgage is subject to tax under the stamp tax, you ask whether the loan, quote, would not be subject to taxation under subsection 1. So, right, again, the stamp tax is broken out into 2 types of transactions, where you just have a loan, a standalone issuance of debt, and when you have a mortgage that's debt on, based on a mortgage on real property. And so what it's saying is that when you have a mortgage, you look to how you would treat the loan even in a standalone loan situation. So it still has to meet those exemption criteria. And so it would still need to show that they were attached and notated. It still needs to be a renewal note. it still needs to
But
show.
under 201.08, the notation on the note, the notation shall be made on the note that the tax has been paid on the mortgage.
Yes.
So that's all it says.
I think that the exemption provision gives more color as to what the style of that notation has to include. But even if you thought that the notation requirement could be more broad, I still don't think they've met the attachment requirement, which is also a separate requirement in the stamp tax exemption provision.
So my understanding was that the denial, like the notice of refund denial, the main basis for denying the refund claim was that the department did not consider these to be renewals. Instead, it considered them to be, because it satisfied the pre-existing obligation and created a new obligation. Can you go into that? Was that the main thrust?
Yeah, so certainly that was the basis why, before the litigation, we denied the refund claim when you talk about the audit period, right? That was certainly that was the primary consideration for denying those claims, especially because the department had a pre-existing rule that says when you have a old loan and a new loan, and when you create the new loan, you separately satisfy the old loan. What may look like a renewal is not a renewal, and that's been a department regulation since 2001 that's gone unchallenged.
Well, how would you ever clean up your paperwork, to put it simply? If you've got a refinance or a renewal, don't you need something filed so that you're not showing there's potentially a viable first loan and second loan? How else would you clean up the books?
Well, I think you certainly could at least, make clear in the new document how what is the nature of the original loan. At least our understanding of the way the legislature wrote the statute is it needs to be a renewal, and that's a term of art it was borrowing that contrasts with a novation, where you're allowed to, where a novation is the type of circumstance you're describing, where you get rid of the old loan and you create a new one. Whereas in this circumstance, you suspend the old loan, so it's not the active loan that you're complying under, but if you default on the new loan, you could sue under either. That's at least our understanding of the
So what pleading
text.
would you file? Instead of it saying satisfaction, what would you file a pleading that says what?
Well, I'm not sure exactly when, I don't know why the bank felt the need to satisfy the old loans. If they were truly suspended by the new loan, and they could just say that in the new loan document, I'm not sure that they needed to suspend, or they needed to completely satisfy the old loans to comply with the statute, and that's our point in this litigation, is that those satisfactions wiped away the old loans, and so there's no obligation to renew.
So I understand your argument for the dock stamp taxes to hinge on renewal under the statutory scheme. Moving to the intangible personal property tax scheme under 199, there it uses the term refinanced. It doesn't use the term renewal. So in 199, 145. Can you explain your argument as to that?
Certainly. So that certainly our arguments are slightly different as to each tax. We're not making the satisfaction argument as cleanly as to the intangible tax. I would say the arguments that go to the intangible tax are our argument that the bank needed to enter the loans in evidence because a refinance, which is the requirement, that's the only exemption criteria I'm aware of under the intangible tax statute, still requires a comparison of the terms of the loans. Because a refinance is the exchange of an old debt for a new one, as Black's Law Dictionary says. And in order to understand the transaction, I think a fact finder would need to be able to compare the terms of those loans. And then our second argument on that front was just about the balances, that without the balances and evidence that we can't make a proper assessment of exactly how much of an exemption they're entitled to. It's similar to a damages claim where a jury is just speculating. So those would be the two arguments that would be relevant to the intangible tax. So if there are no further questions, I'll step down. Thank you, Your Honor.
And why don't we give 5 additional, let's give 2 minutes for a rebuttal, which I think brings this up to, what is that, 1850 plus 2, 2050 or something like that? 21 minutes.
I'm not sure I'll need that much time, but I do appreciate it.
Oh,
Well,
thank you.
you tell me if I need that much time. Good morning. May it please the court. Michael Bowen, Ackerman LLP for Bank of America. I want to hit something right off the top, and and our briefing doesn't do a perfect job of this. There's a distinction, I believe, between the arguments of preservation and waiver, right? They're not exactly the same. We believe, and we argue in the briefs, that the arguments on the factual issues were not preserved below, but we believe more strongly, based on Judge Nordby's questions in particular, that they were waived, and not just waived once. I mean, they were waived at least 3 different times. Counsel cites to the reply brief, but what ultimately happened here is 1 month before the order was issued, Judge Cooper held a 3-hour marathon summary judgment hearing in which he asked counsel, after going through the affidavits over those 3 hours, repeatedly, are there any genuine issues of material fact? Page 548 of the record, Judge Cooper asked counsel, you filed a motion, DOR filed a motion for summary judgment also. So do you contend, as it relates to the plaintiff's motion, there's any disputed issues of material fact? Answer, no, Judge. No issues of material fact. Judge Cooper, over the course of 2 hearings, 4 hours, reviewed the affidavit of Mr. Flatteau in respect to Bank of America and the department's own affidavit of their auditor. Now, let's go back to the audit. When the Bank of America filed its refund claim, they filed a spreadsheet. That spreadsheet was summary in nature, 15 columns, 9,882 loans, demonstrating what the amount of the original loan was, the refinance loan was, when the tax was paid, where the property is, obligors, everything. And this is in detail. In response, the auditor could have asked for anything to prove the claim. The auditor asked for 5 or 6 different items, a couple pages of the mortgage, the first 2 pages, theoretically, I would think, to assume that the tax was paid on the mortgage, and certain other documents. Now, counsel was correct that this is what we're not talking about here is an appeal of the audit. But what happened in this case, as Judge Nordby's indicated, is the affidavit attached the audit results to it, and counsel said, this is our evidence that we're going to be relying on. So it is actually an appeal of the audit results, which they said is sufficient evidence in this case. They didn't ask for anything further from Bank of America to support its claim. And as a result, in light of the factual issues, Judge Cooper, one more thing, they deposed Mr. Flatteau in this case. So it wasn't like at the last minute when we filed the motion for summary judgment, we said, here's our affidavit. They deposed him as a 30B6 rep in this case for Bank of America. They could have asked him anything. They could have asked him to bring anything. They didn't ask any of those questions. They accepted his affidavit. And ultimately, Judge Cooper, who worked as counsel for a bank many years ago and handles plenty of these types of cases in these types of areas in tax, said after 4 hours of summary judgment hearing and reviewing the affidavits, there's no issue material fact, is there? There's no issue material fact, is there? No, 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 no. So at the end of the day, we strongly believe that the arguments below with respect to any factual issues were not preserved, and in fact were waived. And this court's been very clear about those issues and how they impact the ability of the party to appeal.
Moving to the legal arguments as to the language of the statute, specifically the dock stamp tax statutes, can you address the term renewal and how what happened here falls under that term?
Sure. So as you indicated, 208, 201, 09 relating to the renewal. Now, Judge Cooper, again, looked at all the documentation, the affidavits, which in Mr. Flatteau's affidavit was pretty clear as to what happened here. Same obligor, same property, continuing security agreement, refinancing, not really referred to it as a refinancing, but renewals of the note. It's the same security obligation with respect to the continuation of the same loan. And Judge Cooper looked at all that and said, that's a renewal at the end of the day. And there's really, and again, there was no dispute as to any of those facts as a predicate for that conclusion. And so we believe that, you know, clearly under the statute 20109, subparagraph 1, that what we have here is a renewal, although we fall under 2, which ultimately leads to the argument relating to the attachment issue. And our argument with respect to the attachment is that the attachment provision, which refers to promissory notes, That makes sense, right? Because you can have an exemption under 20109 with respect to the renewals of promissory notes. And you could also have, as in this case, the renewal of the mortgage. And what we're talking about here is under 2. We have the renewal of the mortgage, although the prom note comes with it, right? Under 20108, the tax is actually paid on the mortgage. And so when you look, it says under 2 that if the note is exempt, so is the mortgage. Now, the note exemption under subparagraph 1 says that the note has to attach the old note to it. Now, that makes sense under 1 because those aren't recorded instruments. And so if you're going to have a renewal and argue that we have the ability to have this exemption, partial exemption for any additional amounts loaned, you have to demonstrate you paid tax on the original note. That's why the prom note attachment provision in 1 makes sense. But here, the tax is actually paid on the mortgage. It's not notated on the note. And as a result, we qualify under 1 because we didn't have to note on the prom note, we didn't have to attach it because the tax wasn't paid on that document. The tax
What's
is
the
actually paid on the mortgage.
What's the significance of the administrative rule 12B 4.052, which expressly states if the original note and mortgage is satisfied, an instrument that might otherwise appear to be a renewal is taxable on the full amount of the obligation? What do we make of that existing administrative provision? It's still on the books, it's still
Correct.
active.
Well, as you might guess, I have a spectrum of views. My first view is that ultimately what a renewal is defined by 20109. It tells you what a renewal is. Continuing obligation, same obligor, it sets out its own requirements. So our first argument is to the extent that the department, through its rule, it seems as though they're adding another layer, another requirement, or another potential roadblock or obstacle for a taxpayer
But
to.
that rule's never been challenged, right? So do we just ignore it? Are you challenging it in this proceeding? What
We
do
make
we
the,
do?
I apologize. We make the argument that in a largest contravenes, modifies the existing statute, although we didn't challenge we didn't make a rule challenge below, but we make the argument. For example, under the Golden West decision from 2008, similar argument was made in that case. It wasn't a rule challenge. It was just an argument that you can't enlarge, modify, or contravene an existing statute, and this court agreed in that case. In that particular instance, the rule contravened, modified the statute. And we believe that's our first argument. But that's not the only argument. Ultimately, we don't think, even if that provision applied here, because there was no satisfaction, at the end of the day, we did file a satisfaction, as Judge Thomas has indicated. We did so for the benefit of our customers. At the end of the day, if you're looking at the public records, you want to make sure there's only one document there. Going back to the example that's in the briefs, if you have an original $100,000 loan and someone a little bit later that same person wants to borrow another $50,000, according to the department, we can't file a satisfaction of the first loan at all. And if you can't do that, then ultimately there's going to be two filings in the public records, one for a loan of $100,000, one for a loan of $150,000, and creditors are going to see that and say, well, you're on the hook for $250,000 to Bank of America. That's going to hurt your credit potentially. It's a public records issue. And that defeats, I think, the legislative intent of the 1998 amendments to 20109, which was exactly put in place to provide for this type of exemption, partial exemption on the increase in the principal balance.
But 20109, there's also this idea that it must evidence part or all of the original indebtedness. So how is the link established between the new loan and the old loan that you've satisfied? What on the face of it is showing that? Because it seems from 20109, there is some facial requirement that it evidences all or part, that's the first sentence.
Mm-hmm.
And then it goes down and talks about the renewal note evidencing the obligation.
As you might guess, Judge Osterhouse, our first argument is to the extent that that's a factual requirement, that's already been waived here. The department's already agreed pursuant to the original refund claim filing, which we gave them all of the information with respect to all of the loans. And then they requested additional information trying to verify those facts. And the only issue that came up from the auditor, that's again part of the evidentiary record below, is that you failed the satisfaction requirement of the rule. Not that there was no link between evidencing the debt.
Your summary judgment papers and the flat 2 affidavit talked in terms of being blocked by the clerks from filing something that would link the two documents. Now, I don't know much
Correct.
about that other than it's in the affidavit.
Correct.
That I guess was was not controverted. There was no disputed issues of fact.
The clerk would not permit Bank of America to record and qualify for the exemption. The counter clerk said, nope, those are new loans. You need to pay the full tax on the full balance of that new loan, not just the increase.
But it talked in terms of you trying to include a legend or a notation on the mortgage that evidenced the earlier mortgage. Did I read that right, or am I not reading that right?
I'm not sure you're reading that, Judge Osterhouse. At least I'm not familiar with that.
Okay.
But Judge Nordby, I don't know if I answered your question on the reg, and the rule, I'm sorry. One more thing about the rule, and you kind of pointed this out during your questioning earlier, is that we're talking about two different taxes. We're talking about the documentary stamp tax, which the rule, in theory, applies to. And then we had the intangible tax. The intangible tax itself, 199.145, the only requirement is that we have a refinance. The department hasn't issued any rules under 199.145. There's been no case law relating to 199.145, and 199.145 has always provided the exemption that the legislature ultimately put in place in 1998 for the dock stamp. It's always provided that under 199.145.
The Golden West case you referenced, was that in the context of a refund claim, or was it an appeal from an administrative rule challenge?
I don't think it was either. I think it was actually a protest of an assessment. So I don't know if I answered your question on the satisfaction. I hope I did. But again, what we're talking about here are two different taxes. The satisfaction requirement issue does not apply with respect to, at least the department's rule, does not apply with respect to the intangible tax whatsoever. I believe that's all I have.
Thank you.
Thank you, Your Honors. I just want to briefly touch on 2 points that were made. First is this idea about waiver and the factual arguments made below. There's been some discussion about the trial counsel below waiving all of our factual arguments in this case. I just want to make 2 quick responses. The first one is that while maybe not as artfully put it as it should have, given all the time to fully think through all the issues, I think the best way to interpret what trial counsel was saying below is because there was no evidence to prove these legal requirements, all that was left were these legal disputes about if they had nothing to show nothing to show that they met these certain exemption criteria, would they be able to get an exemption? And so I just want to point to some parts in the hearing where I think that's displayed. So if you look at page 557, trial counsel says, of course, we have a lot of legal issues. I don't think we have any fact issues that need to be settled. Trial counsel went on to say that they needed to prove the requirements for the exemptions for both taxes, and then separately the satisfaction argument. So it wasn't just the legal satisfaction argument. I believe trial counsel was also making an argument about what they were using to prove those exemption criteria. That's also shown on page 530, and I also think that that's what the trial court understood. If you look at pages 408 from the first hearing or 535 from the second hearing, the trial court knew that the department was arguing that it should not rely on the affidavit and that there were insufficient documents to prove the exemption criteria. The trial court understood that that objection was being made. It's in our reply, it's at the hearing, and I just want to talk about very briefly about what my friend on the other side said about the attachment and notation requirements. He's asking you to vary the clear text of the statute based on what he thinks would be a better way of administering the exemptions in the mortgage context. But the mortgage provision of 20109 is very clear. It says whether the mortgage is subject to tax depends on whether the loan, quote, would not be subject to tax under subsection 1. And whether a loan under subsection 1 would be subject to tax turns on whether it's attached and whether it's notated properly, whether it's a renewal, and all of the other exemption criteria that are present in subsection 1. Now, the legislature could have written something different. It amended the exemption provision several times, but it did not. And for all these reasons, we would ask you to reverse the denial of summary judgment for the department. Thank you, Your Honors.
Thank you, counsel. Thank both of you for your arguments. We will take it under advisement. This is our only argument for the day, so we're adjourned.